Speaking of demented politicians, let's discuss how the Labour Party are living in the long shadow of Carl Schmitt, and despite citing him, have no idea what he actually wrote. I'm referring, of course, to the Attorney General, Lord Hermer, the highest lawyer in the land, who has taken some unprecedented political interventions into cases recently. So, Laurie Wastell of the Free Speech Union has done some investigative work, and you should follow his work on Twitter and over at the FSU, and found that Lord Hermer and his office personally signed off on the persecution of Lucy Connolly. They had the opportunity to pass it up, but no, instead, he declined to review the unduly lenient sentences given to rapists and a paedophile. But in his constitutional role as the government's chief lawyer, he approved the persecution of Lucy Connolly. However, 3 other criminals all received softer sentences than Connolly, and Lord Hermer himself had encouraged Keir Starmer to break out the racial and religiously aggravated public order offence charges to increase the sentences for those who posted online or went to peaceful protests after the Southport massacre. So Lord Hermer himself politicised the punishments of anyone involved in outrage after Axel Rudakabana murdered 3 girls and stabbed 10 others at a dance class in Southport. However, he didn't think that the sentences of the following criminals needed to be reviewed. So this includes Ben Churcher from Wiltshire, given 28 months in prison for raping a woman in her home. The decision was made not to review the case of Jamie Daniels from Droitwich, who was spared jail after pleading guilty to attempt to incite a 13-year-old girl to engage in sexual activity. He was given 21 months in prison, suspended for 2 years in April. So received no prison time and also got less prison time than Lucy Connolly did for a deleted tweet. On another occasion, he opted not to review the sentence of Far Mohammed. Wonder why. From Essex. Ah yes, from Essex. Who sent money to his nephew in Syria, knowing it was being used to fund terror activity. Now, it's interesting because Lord Hermer has throughout his career defended terrorists, including ISIS bride Shamama Begum, the mother of one of the Jihadi 4, the British ISIS converts. He's defended plenty of other terrorists as well. He's defended Mark Duggan, the thug, whose shooting was the catalyst to the 2011 London riots. Defended all sorts of odious characters. And then he personally brought charges over Twitter against Tommy Robinson for a civil offence in an unprecedented intervention. And it's curious that he did that because he has a long-standing connection to our old friends at Hope Not Hate via the Searchlight magazine. Now, the Searchlight magazine was the precursor to Hope Not Hate. It describes itself as anti-fascist, but given they employ Matthew Collins, a former Nazi, now a member of the British Communist Party, who at 2013 at a Hope Not Hate event stood behind a giant pre-printed Soviet emblem and said, "Comrades, Hope Not Hate, you are our Red Army." Well, if any other institution had employed a Nazi, Hope Not Hate would call them a Nazi organisation. So by that standard, Hope Not Hate are demented open borders communists. So it's fair to characterise them as such. Our Attorney General, Lord Hermer, 3 years after being called to the bar in 1996, was recommended to join Searchlight magazine's management committee. The man who put his name forward was Jerry Gable, someone who should be familiar to everyone who's been looking into the background of Hope Not Hate, who is Searchlight's long-serving editor, who once stood for election for the Communist Party, and in 1980 produced research for BBC Panorama documentary that falsely alleged 2 Conservative Party members were themselves Nazis, and the BBC lost a libel trial and had to pay damages for it. Later, minutes from meetings show that Lord Hermer missed a meeting in June 1999, he was meant to attend, and attended one in November of 1999, alongside Nick Lowles, the CEO of Hope Not Hate, who was then co-editor of Searchlight magazine, and who mysteriously has not been prosecuted for inciting violence after spreading a known hoax that, one, there were acid attacks against Muslim women in Middlesbrough, which then Cleveland police had to come out and correct, because it was cited by members of the Muslim militias who said we are British Pakistanis and that our Muslim sisters are getting acid attacked, which is why they turned out on the streets armed with weapons. And also the fact that he spread the hoax that there were going to be hundreds of far-right riots, which then mysteriously mobilised Stand Up to Racism protesters with placards on the streets, and just so happened to be on the front page of every newspaper the following day. That was also the protest where Labour councillor for Dartford, Ricky Jones, called to slit the throats of the protesters that were supposed to have materialised but did not. Ricky Jones is still not being tried. Weird that, how you could expedite the trials of all the people that post on social media, but when someone, does an imminent incitement to violence on camera, well, if he's a friend of the regime, he gets treated very lightly. Lord Hermer, was still part of Searchlight Research Associates as late as 2016. How fascinating. And then it mentions Mr. Robinson in here. When Robinson courted a contempt of court charge for playing his film Silenced at a rally at Trafalgar Square in 2024, Nick Lowles informed the Attorney General's office the film had been played at the protest and therefore incited the contempt of court charge to be brought forward. So, Lord Hermer is an avowedly communist political actor. Which brings us to his recent speech. Now, this is very interesting. This is the annual speech. This is the RUSI Annual Security Lecture at the Royal United Services Institute, and he gave the speech on the 29th of May 2025. And there was an interesting moment in here where he just compared his political opponents to the Nazis, which is, of course, par for the course for anyone involved in Hope Not Hate, Searchlight, or communist leftist activism. It's as Jake Scott wrote in The Critic on this speech recently, it's the admission of the loss of an argument when you resort to the puerile schoolgirl tactic of reputation destruction. But Lord Hermer gave an interesting note in this speech about international law, and I want to talk about it because he brings up the philosopher Carl Schmitt, the German jurist who, prior to the rise of the Nazi regime, was discussing legal theory, then erroneously joined the Nazi Party, then renounced his membership later on, and whose work was translated by Jewish and left-wing academics in America because they wanted to contend with his criticisms of the neutrality of institutions, the possibility of law to govern for all peoples, and the idea that liberalism is a non-comprehensive system. The idea that you can depoliticize politics. Schmitt makes some very interesting critiques, and we're going to go through Schmitt's work in light of the fact that Lord Hermer invoked his name to smear his political opponents. So Hermer says, "Allow me to explain how our policy of progressive realism, his doctrine of international law and politics, meets this moment, and the role of the law and the international rules-based order plays in our approach. Because our approach is a rejection of the siren song that can, sadly, now be heard in the Palace of Westminster and in some spectrums of the media, that Britain abandons the constraints of international law in favour of raw power. This is not a new song. The claim that international law is fine as far as it goes, but can be put aside when conditions change, is a claim that was made in the early 1930s by realist jurists in Germany, most notably Carl Schmitt, whose central thesis was, in essence, the claim that state power is all that counts, not law. Because of the experience of what followed in 1933, far-sighted individuals rebuilt and transformed the institutions of international law, as well as internal constitutional law. Now, part of our pragmatic approach to foreign affairs is to learn from experience, to analyse without preconception or dogma what has been shown to protect British interests in the world and what has not. Schmitt's so-called realism has for 80 years been refuted by the fact that these institutions, post-45 institutions, have provided the basis until now for Western and other states, wildly varied in nature, to interact with each other under conditions of peace and stability, all while pursuing their own strategic interests. Raw wild power on its own in so many different calculi has rarely been picked as a modus operandi because it is not a realistic way to advance national interests. Now, drawing on historical experience, it is important to stress the role of Britain in the rebuilding of the post-war consensus. I was told that phrase was woke right. In the development of international law and multinational institutions, all a rejection of the discredited Schmittian conception of power. Our role, then, in Yalta, in San Francisco, in Bretton Woods, and beyond, helps explain why so many look to us for a leadership role now. There is a temptation among its critics to see international law as something inflicted upon us by others, as something undemocratic and somehow foreign. Such assertions frankly smear the great British historic success in providing the international leadership that has established and shaped so much of the rules-based international order. That order was built in the 20th century on the ideas forged by great British international lawyers, notably Sir Hersch Lauterpacht, the Cambridge Professor of International Law and Britain's Judge on the International Court of Justice. We should not forget that it was a Conservative politician, David Maxwell Fyfe, who was one of the principal drafters of the European Convention on Human Rights. Right. Now, we're going to go piece by piece here, because Lord Hermer commits a number of sins and inadvertently proves Carl Schmitt's critique of international law and liberalism true. And there really seems to be a sort of Schmittianism in the air if now the highest law in the land is invoking the talking points of what would have formerly been marginalized or referred to as the dissident right or the online right. So, as he says, the most notable claim, the most central thesis of Carl Schmitt was that state power is all that counts, not law. Now, this is partially true. We'll go here to a quote that my friend Harrison Pitt placed in his article, The Carl Schmitt Craze in the European Conservative. Prior to the First World War, Schmitt subscribed to an idealist conception of the state which held that justice exists prior to man-made legal systems. Now, this can still be the case with a Schmittian interpretation of how law works. You can say there is an objective morality. There is a system of law which is most conducive to human flourishing. But indigestible, tribal, and cultural barriers present problems for adoption. And so, there may be different legal systems, different pathways to the different estuaries to the same river of objective truth that runs through the human experience. And some cultures and countries over others may access it faster, and some may never access it at all because their underlying cultural suppositions are so awful. However, after the First World War, as Harrison writes, positive law is thus an inadequate copy of its ideal, and may even forfeit its status as law altogether if it fails to reflect this moral order. He later came to embrace the more recognizably Schmittian maxim of Thomas Hobbes, authoritas non veritas facit legem. Authority, not truth, makes law. And so, like it or not, what undergirds law may be more or less morally true for one law or another, but in the final analysis, it's the authority which makes and enforces the law which determines whether or not the law is binding, whether or not it is successful, whether or not it is legitimate. This is Schmitt's concept of sovereignty. It is state power that declares exceptions and rules regarding the law. And then Hermer says, because of the experience of what followed in 1933, far-sighted individuals rebuilt and transformed the institutions of international law as well as our internal constitutional law. Now, note there, Hermer is drawing connective tissue between the 1997 and onwards Blair constitutional revolution, the instantiation of a Supreme Court, the creation of constitutional crisis that puts a unelected court above parliamentary sovereignty, and the putting on rails of the civil service as an ostensibly neutral institution by the 2010 Constitutional Reform and Governance Act, as well as the 2005 Constitutional Reform Act, that says that Parliament is no longer sovereign, it is bound up by legal treaties, as well as the 1998 Human Rights Act, which Keir Starmer wrote the textbook on how lawyers should interpret, and Keir Starmer and Lord Hermer have been friends for decades, that binds the UK courts to the resolutions of the European Convention on Human Rights and the European Court of Human Rights. He is saying that that has legitimacy and connective tissue with all of the instantiation of binding legal institutions like the European Convention on Human Rights and its court, and the United Nations and its Refugee Convention in the immediate aftermath of the Second World War. So what he's doing there is saying, well, if you object to how your country is currently being run by demented activist judges and lawyers like Lord Hermer, then you are indistinguishable from people that would have turned away Dutch Jews fleeing the Holocaust in the 1940s. Complete well poisoning, as we come to expect. And as far as it goes, though, as a legal argument, he's not wrong. Because the creation of a human rights legal framework, an international human rights legal framework, may have been laid with the best intentions to protect those Jews fleeing the Holocaust, but because it is premised on a universalist understanding of human nature, the belief that culture, education, and economics are all arbitrary disparities that can be resolved by the state to unleash a latent egalitarianism between men from Manchester and men from Mogadishu, that there is such thing as a law that is applicable for all people in all times and all places, and that human reason, thinking out from the original thought experiment of the blank slate, the state of nature, human reason, if applied under a Rawlsian veil of ignorance, can run thought experiments and create laws that apply to people in all times and all places. So we don't need to recognize intractable cultural differences. We don't need to recognize the parochial preferences of different people in different places and different governance structures. Instead, there can be one global government that is acting in the presumed best interests of all people, even if they don't know it yet. And so, you don't actually need democracy. It is, in fact, democratic according to Lord Hermer and liberal ideologues, to instantiate the rule of experts and lawyers over and above elected parliamentary sovereignty, because the stated preferences of the people don't count. They might be labouring under a false consciousness of inequality, and so it is the job of unelected experts to realise their equality, because it's actually in their best interests. So it's actually maximally democratic to not be elected at all. I recommend reading Emily Finley's book, The Ideology of Democratism, for this. And so, he is correct, there is connective tissue between the Blair Revolution in Britain and the legal revolution following the Second World War. The reason he's uncomfortable with pointing that out is because unpicking the Blair Revolution, which is holding our country back, also requires unpicking a lot of those legal doctrines that were put in place by well-meaning people like Winston Churchill, wanting to protect Dutch Jews from fleeing the Holocaust, and now apply to North African rapists breaking in via small boat over the English Channel. And also, when he mentions, the irony of him mentioning Yalta and Bretton Woods here, by the way, Bretton Woods are representative of John Maynard Keynes, Keynesian economist, whose economic theory, being currently practiced by Rachel Reeves over at the Treasury, is indebting us to the tune of billions and is going to cause a sovereign debt crisis, and has ruined the economies of pretty much everyone under the global American empire, who are never going to be able to pay back its own debt. So, and has made it an intractable political problem that politicians feel they can't actually deal with the unstable nature of the economy, or else they're going to lose votes. I mean, see the big beautiful budget that currently Elon Musk is speaking out against in the name of fiscal responsibility over in the US. But he also mentions Yalta, and the Yalta conference and the Tehran conference as well shows the Soviet influence on the post-war settlement, where Churchill was basically squeezed out by Roosevelt, who himself admired fascists and had his State Department packed to the rafters with communists and was going a bit doolally himself, and Stalin, who wanted to carve up Europe between the Soviet bloc and the American sphere of influence, and also, in the post-war settlement, the undue influence of the Soviet Union over the UN's Universal Declaration on Human Rights, where they augmented the right to free speech to mean a right to expression up until the point where the state deems that it's a threat to national security, because they said, well, we need provisions so that the state can crack down on Nazi elements. And, of course, if, like Lord Hermer and Searchlight, and Hope Not Hate, you mischaracterize your opposition as a Nazi for objecting to unvetted, unfettered mass migration, then that allows you to crack down on any of your political opposition with the pretexts of anti-Nazi action. So Lord Hermer is basically admitting that he's in favour of the Soviet meddling in the post-war legal settlement, and he wants this to stay in place because he can attack his political enemies as Nazis and devotees of the evil Carl Schmitt, even though Carl Schmitt made some very good critiques. Yes, he's come out and subsequently sort of apologised this. He says, oh, it was a clumsy reference to Nazi Germany. No, it was a sustained reference, and it was pre-written, presumably signed off on by the Prime Minister, his best friend, and you had a very thought-out critique of what you thought was Carl Schmitt's position. But the issue that Hermer has now presented is that he's proven the Labour government labour under the long shadow of Carl Schmitt, because he has basically proven Carl Schmitt's critique of the friend-enemy distinction and the inability for institutions to be neutral to be correct. Because he said at once, international law is a neutral, unimpeachable standard by which all people in all times and all places can be governed by. And also, it's an instrument for us to realise our pragmatic approach of what he calls progressive realism. So the law is itself an instrument of ideology, but also you're an evil Carl Schmittian if you notice that the law isn't neutral and that we're using it to political ends. Like, he's proving him true. And he's also proving Carl Schmitt's central insight to the nature of politics with a capital P, the political, in concept of the political, which I think is on the shelf behind me. He's proving it true because they are playing blatant friend-enemy politics. So this is bound up with Schmitt's critique of liberalism as a non-neutral doctrine, right? And so I'm going to read a little bit from the following essay that I wrote on Monday for my Substack on Labour's friend-enemy politics here, because I think it summarises it as best as I can muster. So Lord Hermer is a member of what Spanish critic of the French Revolution, Juan Donoso Cortés, called La clases discutidas. My Spanish is terrible, but he means the discussing class, and this is what Schmitt referenced in political theology. His counter-revolutionary counterpart in England, Edmund Burke, called them the much more pronounceable men of political letters. So Schmitt lamented how these lettered intellectual liberals will freeze any action in amber with infernal discussion and pretense of being neutral arbiters. So he said, a method of circumventing responsibility and of ascribing to freedom of speech and of the press an excessive importance that in the final analysis permits the decision to be evaded. Just as liberalism discussed and negotiated every political detail, so it also wants to dissolve metaphysical truth in a discussion. The essence of liberalism is negotiation, a cautious half measure, in the hope that the definitive dispute, the bloody decisive battle, could be transformed into a parliamentary debate and permit the discussion to be suspended in an everlasting discussion. The decision to be suspended in an everlasting discussion. So basically, international law acts as the ostensibly neutral arbiter to mediate every single interaction and discussion where there might be a power imbalance or an incommensurate competition of conceptions of the good, and make concessions that apparently benefit both parties, but as Lord Hermer has admitted, progressive realism actually just benefits the progressive side. So Schmitt's argument was that in miring all competitions between visions of the good life in liberal debate, eventually a ostensibly neutral arbiter will come in and mediate the discussion and cleave in favour of one party while pretending to be a neutral arbiter working on behalf of both parties. So Tracy B. Strong is an American academic, and he wrote in his introduction to Schmitt's concept of the political, if a liberal is a person who cannot take his own side in an argument, a liberal is also a person who, as Schmitt notes, thereby raising the stakes if asked Christ or Barabbas, in the famous Tale of the Passion, responds with a proposal to adjourn or appoint a committee of investigation, by which point the wrong man has already been crucified. Inactivity itself is not a neutral act, because you are, like Pontius Pilate, condemning one conception of the good to death by refusing to involve yourself in its defence, or by arbitrating on behalf of one conception of good against the other, while pretending to make concessions which benefit both sides. By positioning international law as both the neutral accord of the post-war consensus, befitting the latent blank slate egalitarian nature of all peoples, and capable of enforcing a normative conception of the good, progressive realism, Lord Hermer is just proving Schmitt's critique correct. The post-war consensus is not value neutral. It has a coherent mythology which justifies its expansive state power. Procedural liberalism emerged as the mediating force between the competing conceptions of the good, which were feeled to scale up into totalitarianism. This is what Karl Popper would call the open society. We need to be pathologically open to value pluralism, otherwise we would be accused of being closed-minded, racialists, and leading ineluctably towards the kind of fascism which erected the guard towers of Dachau. The drive toward depoliticization of all issues, to put politics on rails, moving ineluctably towards progressive utopia, is to avoid any one vision of the good from winning out. And this is, as I wrote for the European Conservative, expressed by the dismissal of culture wars by the likes of Lisa Nandy as itself a distraction. Incompatible and competing conceptions of the good are imported within the parameters of the liberal state. Islam versus Christianity. But when an inevitable clash occurs, see the Civil War warnings of David Betts and Dominic Cummings, its existential nature is marginalized by managers who hope the precise allocation of material resources will ameliorate all conflicts. People are treated as fungible, interchangeable integers from a spreadsheet's eye view. This is in market interest, with an increase in the working population creating competition for wages, driving down the cost of labour, and increasing the recruitment pool from which the exceptionally productive can be drawn. But it is inconsiderate of anything but the liberty of the individual to earn disposable income and consume commodities in isolation from culture, history, and social responsibilities. And so, the individual stands naked and afraid before the might of the state, the sovereign. Lord Hermer is pretending that Carl Schmitt's critique of sovereignty is illegitimate, when he's actually saying that sovereignty itself lies in international law. And international law is interpreted and applied by international lawyers, of whom he is a member of that class, as is Keir Starmer. So all he's saying is, do not question my sovereignty and my ability to declare who is a political friend and who is a political enemy. And the political friend-enemy distinction is the most important thing here. So Schmitt wrote of the rules-based international order in the concept of the political. In this case, the rule of law means nothing else than the legitimation of a specific status quo, the rule of lawyers like Hermer, the preservation of which interests particularly those whose political power or economic advantage would stabilize itself in this law. So, the ideology of liberal egalitarianism and of communism that Hermer and Starmer have supported throughout their lives is embedded and enabled by the international rules-based liberal order that was meddled with by the Soviet Union and put on steroids and rails by Tony Blair and Keir Starmer in 1998. So, international law enables the doctrine of progressive realism to cleave in favour of the progressives, like Starmer and Hermer, empowering them to attack their political enemies, to inflict penalties on the successful, who it deems to be robbing from the third world and impoverished minorities, to level everything down to the lowest common denominator by discrimination based on race and by taxpayer redistribution. And this makes discrimination part itself of liberal proceduralism, aiming at absolute egalitarianism. So the law has become an instrument of political activism for the likes of Hermer and Starmer, and Schmitt just points this out. He pointed this out well before the instantiation of the rules-based liberal international order, and almost 100 years, or about 100 years actually, before Lord Hermer could invoke his name to critique something that he himself is admitting to doing. And Schmitt called this global domain of the rules-based international order the total state. So he writes in Concept of the Political, the equation state equals politics becomes erroneous and deceptive at exactly the moment when state and society penetrate each other. What had been up to that point affairs of state become thereby social matters, and vice versa, what had been purely social matters become affairs of state, as must necessarily occur in a democratically organised unit. Heretofore ostensibly neutral domains, religion, culture, education, the economy, then cease to be neutral in the sense that they do not pertain to state and politics. As a polemical concept against such neutralizations and depoliticizations, the removal of the friend-enemy distinction, of important domains appears the total state, which potentially embraces every domain. So the inability to distinguish what is neutral and depoliticized allows the state to take everything into consideration, to depoliticize it, by decreeing the state's conception of the good to be the one true binding one. For international law to be the only legitimate law, and therefore international lawyers to be the only legitimate sovereigns. Schmitt writes, the political entity presupposes the real existence of an enemy, and therefore coexistence with another political entity. As long as a state exists, there will always thus be in the world more than just one state. A world state which embraces the entire globe and all of humanity cannot exist. The political world is a pluriverse, not a universe. In this sense, every theory of state is pluralistic, even though in a different way from the domestic theory of pluralism discussed in section 4 of his book. The political entity cannot by its very nature be universal in the sense of embracing all of humanity in the entire world, so the blank slate is impossible. If the different states, religions, classes, and other human groupings on Earth should be so unified that a conflict among them is impossible and even inconceivable, and if civil war should be forever foreclosed in a realm which embraces the globe, then the distinction of friend and enemy would also cease. What remains is neither politics nor state, but culture, civilization, economics, morality, law, art, entertainment, etc. If and when this condition will appear, I do not know. At the moment, this is not the case, and it is self-deluding to believe that the termination of a modern war would lead to world peace, thus setting forth the idyllic goal of complete and final depoliticization, simply because a war between the great powers today may easily turn into a world war. And he didn't just mean a world war involving the great powers of the world, but if the world become one total state, then an unforeseen disaster would inflict collective punishment upon the world, including the unforeseen disaster of an outside force acting on humanity as a world. And he didn't just mean like an alien invasion in the likes of Watchmen, but he was talking in biblical terms, so a sort of a rapture, sort of demonic force that would inflict disaster upon the human population as a whole. And you can either read that as metaphor or read it literally. And this anxiety about the world state that could bind all human beings together, resolve all conflicts, and then blind them to an existential threat that emerges is why Schmitt formally called Thomas Hobbes the premier philosopher. And when Leo Strauss pointed this contradiction out, he revised his notes and said that Thomas Hobbes presents a important philosophical theory, but that Schmitt no longer abided by it, because actually the liberal state scales up into the total state, premised on the belief that it can construct international laws that bind and apply to all peoples. Schmitt writes, for many people, the ideal of a global organization means nothing else than the utopian idea of total depoliticization, to render all contradictions and competitions between visions of the good that are incommensurate matters of discussion, matters of arbitration by liberal international lawyers, and matters of creating a homogenizing world government which will then be blind to existential threats. And the irony is that while pretending to resolve all contradictions, to depoliticize things with international law, Starmer and Hermer, by calling their opponents Nazis, are playing classic friend-enemy politics. Schmitt writes, each political participant is in a position to judge whether the adversary, the enemy, intends to negate his opponent's way of life, and therefore must be repulsed or fought in order to preserve one's own form of existence. The friend, enemy, and combat concepts receive their real meaning precisely because they refer to the real possibility of physical killing. War follows from enmity. War is the existential negation of the enemy. It is the most extreme consequence of enmity. It does not have to be common, normal, something ideal or desirable, but it must nevertheless remain a real possibility for as long as the concept of the enemy remains valid. Liberalism, in one of its typical dilemmas of intellect and economics, has attempted to transform the enemy from the viewpoint of economics into a competitor, and from the intellectual point into a debating adversary. And from the legal standpoint, just one lawyer among many in the courtroom, dueling over the interpretation of the same set of laws. If you step beyond the boundaries of law, however, the reaction by Lord Hermer and Keir Starmer reveals you to be their incommensurate enemy. And I put in here some quotes from Alistair MacIntyre, the recently deceased philosopher, that said that we now lack the moral language to resolve disputes between our conception of the good because they're based on completely different moral priors. For example, the far right, who are comfortable with inequality because they do not believe in the blank slate rendition of human nature, which is why the likes of anarcho-capitalist libertarians are happy with inequality, and traditional conservatives are happy with a differing legal tradition, the international law, because they believe it befits their people rather than a universal people, versus the people who, communists like Hermer, and even the Liberals and the Tory party who don't want to leave the ECHR, believe in this universal standard human, and so they just have competing visions of human anthropology, and so can't resolve their differences. So this is where the friend-enemy camps emerge. It's the liberal establishment who believe in the blank slate, and the parochial traditionalist conservatives and libertarians who believe that no, there's not just one universal standard human for whom you can make a binding treatise of international law and global government. Actually, we're different peoples with different interests, different countries, different families, different visions of the good that we can put forward, and ultimately, even though it's undesirable, have to defend our vision of the good with force if we are aggressed against. And ironically, Lord Hermer and Keir Starmer, while pretending this friend-enemy distinction by Schmitt doesn't exist, are playing classic friend-enemy politics. This is Schmitt's friend-enemy distinction. The specific political distinction to which political actions and motives can be reduced is that between friend and enemy. Each participant is in a position to judge whether the adversary intends to negate his opponent's way of life and therefore must be repulsed or fought in order to preserve one's own form of existence. The inherently objective nature and autonomy of the political becomes evident by virtue of its being able to treat, distinguish, and comprehend the friend-enemy antithesis independently of other antitheses. This is exactly the existential political distinction that Labour, Lord Hermer, Keir Starmer make when comparing their opponents to the Nazis. So they're playing on the prejudices of the post-war paradigm while pretending that they're not playing friend-enemy politics. This is the exact pretense of neutrality that Schmitt was critiquing for liberalism and international law. So they can struggle in the shadow of Carl Schmitt all they like, but all they're doing is proving him correct. And I think people are starting to realize this, and that's why the appetite for staying within the trappings of liberal international law and the rules-based international order, which demands your country be flooded to the rafters with foreign criminals, the appetite for keeping that settlement in place is waning among many sensible people who haven't even read Schmitt. But I'm glad that Lord Hermer has now brought awareness of, let's say, Germany's most controversial but insightful jurist to broader public attention.